Principles of natural justice. So, principles of natural justice is derived from the word jus natural of the Roman law, and it is closely related to common law and moral principles, but is not codified. It is a law of nature which is not derived from any statute or constitution. The principle of natural justice is adhered by all the citizens of civilized state with supreme importance. In the ancient days of fair practice, at the time when industrial areas ruled with a harsh and rigid law to hire and fire, the Supreme Court gave its command with the passage of duration and established of social justice and economic statutory protection for the workmen. So, natural justice simply means to make a sensible and reasonable decision making procedure on a particular issue. Sometimes it does not matter what is the reasonable decision, but in the end, what matters is the procedure and who all are engaged in taking the reasonable decision. It is not restricted within the concept of fairness, it has different colors and shades which vary from the context. So basically, natural justice consists of three rules. The first one is hearing rule, the second is bias rule, the third is reasons decision. The hearing rule, which states that the person or party who is affected by the decision made by the panel of expert members should be given a fair opportunity to express his point of view to defend himself. Bias rule generally expresses that panel of expert should be biased free while taking the decision. The decision should be given in a free and fair manner which can fulfill the rule of natural justice. Thirdly, reasoned decision, which states that order, decision, or judgment of the court given by the presiding authorities with a valid and reasonable ground. Now, the origin. So, the principle of natural justice is a very old concept and it originated at an early age. The people of Greek and Roman were also familiar with this concept. In the days of Kautilya, Arthashastra, and Adam were acknowledged the concept of natural justice. According to Bible, in case of Eve and Adam, when they ate the fruit of knowledge, they were forbidden by the God. Before giving the sentence, Eve was given a fair chance to defend himself, and the same process was followed in the case of Adam too. Later on, the concept of natural justice was accepted by the English jurist. The word natural justice is derived from the Roman word jus naturale and lex naturale, which planned the principles of natural justice, natural law, and equity. Natural justice is a sense of what is wrong and what is right. In India, this concept was introduced at an early time. In case of Mohinder Singh Grill versus Chief Election Commissioner, the court held that the concept of fairness should be in every action, whether it is judicial, quasi-judicial, administrative, and or quasi-administrative work. Now, the purpose of the principle is to provide equal opportunity of being heard, concept of fairness, to fulfill the gaps and loopholes of the law, to protect the fundamental rights, basic features of the constitution, to miscarriage of justice. The principles of natural justice should be free from bias and parties should be given fair opportunity to be heard, and all the reasons and decisions taken by the court should be informed by the court to the respective parties. Supreme Court said that arriving at a reasonable and justifiable judgment is the purpose of judicial and administrative bodies. The main purpose of natural justice is to prevent the act of miscarriage of justice. A committee, that is minister's power, gave three essential procedures related to principle of natural justice. First, no one should be a judge in his own matter. Second, no one can be condemned unheard. Third, the party is entitled to know each and every reason and the decision taken by the authority. Now, when it can be claimed, natural justice can be claimed when acting judicially or quasi-judicially, like panchayat and tribunals, etc. as well. It includes the concept of fairness, basic moral principles, and various different kinds of biases, and why the natural justice is required, and what all special cases or situation it includes where the principle of natural justice will not be applicable. In the case of Province of Bombay versus Khushladаш Advani, it was said that natural justice will be applicable on statutory as it is basic principle of natural justice which leads to fairness and justice. Then rules of natural justice are nemo judex in causa, which means no one should be a judge in his own case. Ordo alterum partem, which means no person can be condemned or punished by the court without having a fair opportunity of being heard. Reasoned decision, basically, it has three grounds on which it relies: that the aggrieved party has the chance to demonstrate before the appellate and the revisional court that what was the reason which makes the authority to reject it. Then it is satisfactory part of the party against whom the decision is made. And the third ground is the responsibility to record reasons works as obstacles against arbitrary action by the judiciary power vested in the executive authority. Now the conclusion. So the principle of natural justice have been adopted and followed by the judiciary to protect public rights against the arbitrary decision by the administrative authority. One can easily see that the rule of natural justice include the concept of fairness. They stay alive and support to safeguard the fair dealing. So, at all the stages of procedure, if any authority is given of the judicial function is not purely accepted, but the main motive of the principle is to prevent the miscarriage of justice. It is supreme to note that any decision or order which violates the natural justice will be declared as null and void in nature. Hence, one must carry in mind that the principles of natural justice are essential for any administrative settlement to be held valid. The principle of natural justice is not confined to restricted walls. The applicability of the principle but depends upon the characteristics of jurisdiction grant to the administrative authority and upon the nature of rights affected of the individual. That's all. Thank you.